Good afternoon to all. Today in the afternoon, we have two sessions, and we have with us Justice A.K. Sikri, former Judge, Supreme Court of India, and presently Judge, International Commercial Court, Singapore. I have great pleasure in introducing him. In fact, Justice Sikri is a unique judge. With 22 years as a lawyer and 20 years as a judge, starting his journey in the year 1977, designated senior advocate in 1997, elevated in the year 1999, and he came to us as Chief Justice of Punjab and Haryana High Court in the year 2012. In the year 2013, he was elevated to the Supreme Court of India, from where he retired on 6th of March 2019. In this long journey of Justice Sikri, I have enjoyed a unique relationship with a unique judge in different positions for that matter. He has been regularly coming to the National Judicial Academy and then thereafter to Chandigarh Judicial Academy. Chandigarh has been a second home for him for that particular matter as such. And therefore, we could not have found a better person to deal with the two aspects which he would be dealing this afternoon: the interplay between the Commercial Courts Act and the Arbitration and Constellation Act. That is one part. In the fourth session of the day, with a short break of 15 minutes thereafter, we would have the fifth session relating to construction and infrastructure contracts, both by Justice Sikri. I'm grateful to him for accepting a request and sparing his time. I know how busy and demanding his schedule has been, but he has never disappointed us. Sir, very kind of you to have accepted a request. I have pleasure in presenting Justice A.K. Sikri.
Thank you, Dr. Professor, Senior Advocate Dr. Balram Gupta, and the Director of Judicial Academy. My good afternoon to all those who are attendees today and have taken out their time to listen to me. I hope that I'll be able to say something which may be relevant for all of you. Both the topics which are chosen, of course, along with other topics which I have seen the program which was sent, are really very relevant in today's time, particularly when we discuss the issues pertaining to commercial disputes and resolution of those commercial disputes, which may be by means of or through the process of court, or it may be through the process of arbitration. In fact, as far as commercial disputes are concerned, I would say that, of course, all kinds of disputes, the resolution thereof is essential in a speedy manner. It should be cost effective as well. But when it comes to the deciding of the commercial disputes, that occupies a very different and special place. It is because of the various reasons, and I will not go into details thereof, but just flagged the points. just to understand the importance. We are no longer, after 1991, a country which is cocooned in the sense insofar as business activities are concerned. A very important step was taken for liberalization and globalization of Indian economy by the then Prime Minister, Mr. Narasimha Rao, and this visionary step which was taken by or initiated at the instance of Dr. Manmohan Singh ji, who was then the finance minister. Various reasons because of which it happened, again, it need not be gone into. But what I'm trying to stress is that with this, insofar as trade and commerce is concerned, there was the boundaries or international boundaries got blurred, because it is not only India which has ushered into globalization in 1991, but there are many countries who had rather started it much before, including China. And therefore, China still is ahead of us insofar as growth of economy is concerned. Of course, annual growth now for last few years, which India is witnessing, is better than China, but overall Chinese economic growth is far better. But I'm not into that aspect also. What I want to say is that, and that is, I'm saying from my personal experience also, insofar as legal regime is concerned. I remember I became a judge in 1999, and I remember before that, we used to do commercial matters, including arbitration, etc. Most of these were domestic. Likewise, even intellectual property disputes, because they have their relevance as far as commercial disputes are concerned. Those disputes are also related, almost domestic in nature, primarily of trademark, infringement of trademark, to some extent copyright, patents, etc. But what happened after globalization was that the domestic laws of each countries, be it arbitration, be it IPR, be it any other, in IPR we include Designs Act, Patents Act, Trademarks Act, Copyright Act, and other acts, and many other legislations. It became necessary that they are international compliant. And if you remember, we had Arbitration Act of 1940, and it was, and the act was repealed, and in 1996, within 4 or 5 years after this, we entered the globalization, this act was passed. And importantly, this act was passed on the model law which was prescribed by UNCITRAL. And this model law is adopted by almost 200 countries today. A figure should be, I don't remember, 160, 170, or maybe close to 200. This is happened, and insofar as these intellectual property laws are concerned, Electricity Act, aviation policies, etc., they all underwent change. And what was necessary was to have a synergy of laws, because what is the fundamental principles on which these laws are based, they should be almost on similar lines in all jurisdiction, in all countries. That was the attempt which was made by most of the countries. UNCITRAL came out with many such laws, including mediation law recently, on which Singapore Convention is was held about 2 years ago. Singapore law is passed on that basis. Mediation is adopted, I would say. And our IPR also, because of WIPO, they came out that these should be the international standards on the basis of which all these laws would be passed. Reason was this, that the many issues which were of they were within the, we would say, boundaries of India, or what we call domestic issues, they started having implication of international or international ramifications. As I said, in 1999, when I became judge, most of these arbitrations were domestic. Of course, not that they were not international arbitration, they were. I mean, and New York Convention, etc., they were passed way back in 50s, 60s. But the quantum was very less. Today, and after this, the complexion has totally changed. We have most of the issues in arbitration are complex. Many issues are such which have the international implication. It is because after globalization, FDI, foreign direct investment coming into India, collaborations taking place, say between an industry in India and, for an example, an industry in say Germany or Japan. Technology is given under those collaborations agreement to India, but then disputes may arise. So therefore, what I'm trying to say here is that we have to have international pragmatic approach even while deciding our domestic issues, which principles which are laid down. And over a period of time, and if you see in last few years, Indian government also has been talking about ease of doing business. And there has always been either by the World Bank or any other world organization, ranking of the countries on ease of doing business, on enforcement of the contracts, on enforcement of the awards, etc., where they rank with different countries. And we have been there making strides in the sense that we were almost at 160, came to 130, 40 a few years ago, 100, and we have now even, closer to 60 or rank 60 or 70. So all these things become necessary, and they have the impact on the laws as well. Why I have taken few minutes to emphasize this, that when we come to the issues, of course, the two topics which are given to me now, at present we are discussing about interplay between Commercial Courts Act and Arbitration and Constellation Act, to which I will advert to shortly. But the next topic also about the construction law, this background or this introduction becomes important. Now, therefore, keeping in mind international ethos, keeping in mind international standards, and where today the countries are rated like that, it becomes important for us and the judiciary also to decide, as far as legislature is concerned, yes, for them to pass laws which are international compliant, and for the judiciary also to enforce those laws by giving the interpretation which is pragmatic and which is in consonance with the international practices. And of course, there are fundamental principles which are there. Now, in this entire background, as I said, first Arbitration and Constellation Act of 1996 was enacted on the model law which was given by the UNCITRAL. And there was a complete departure from 1940 Act, which was perceived as archaic law by that time, which was passed 56 years ago, was no more relevant law. What is the importance, or what is there? Of course, when we talk of arbitration, it is a means of alternate dispute resolution, where the parties do not want to litigate in the courts, and they choose their own forum in the form of arbitration. And it is what we call party autonomy, that it is the parties who have decided that we will remain outside the court system, insofar as resolution of disputes is concerned. But arbitration is a hybrid system where support of the court is always needed. Under the Arbitration Act also, if say arbitrator is to be appointed and the parties are not able to appoint, the court has to appoint. Wherever during the arbitration proceedings also some assistance of court is required, say summoning of witnesses, contempt of court, etc., courts come into play. Even after the award is given, it has to be enforced. Again, we fall back on the courts. So therefore, it is called hybrid system. And the main emphasis is on that, which I say party autonomy, on which I would come to. But then it was also thought that it is not necessary that in all the cases the parties would resort to arbitration. So if they don't resort to, ordinary courts are there. But then for the commercial disputes, should we have the same approach that where the civil court, if it is dispute commercial dispute arises, various kinds of issues can be there. But then in the absence of arbitration agreement, if it is not there between the parties, naturally a civil suit would be filed. So earlier, there was no such demarcation that a civil suit, a civil court, whether it is district court or high court, where the high court has the original jurisdiction like Delhi, Bombay, Madras, Calcutta, etc. And therefore the suit will be filed in those courts. But a civil court is dealing with this commercial suit along with other suits also. So should we give another, a separate significance to this? In order to realize that no, we should, even if the suit is filed in the commercial court, there has to be a special thrust given to it. Commercial Courts Act was enacted in 2015. So this is what you have to now keep in mind, that look, if the parties want to choose arbitration, they go for arbitration, but naturally assistance of the court since it is a hybrid system, as I said, it may be required. But if they don't want to take the route of arbitration, it is in the court. It should be now, such cases should be decided, which are described as commercial disputes under the Commercial Court Act itself, should come before the commercial courts. Now, to this extent, there is no problem. But what happens is that even Commercial Court Act talks about the arbitration to some extent. And if you see, this is so mentioned in section 10, which talks of jurisdiction in respect of arbitration matters. So to some extent, and that is what we would discuss, that jurisdiction in respect of even arbitration matters is given to commercial courts. Now, in this situation, when the interplay of commercial courts on the one hand and many issues arise, and Arbitration and Constellation Act, because Arbitration and Constellation Act also provides for complete machinery. Even if the Commercial Courts Act was not there, arbitration of its own was naturally being implemented, whether it was appointment of arbitrator or it was the enforcement of the awards or challenge of the award, etc. So courts were there, civil courts were doing, but now we have commercial courts. And section 10 says jurisdiction in respect of arbitration matter, it is vested in the commercial courts. So in the process, issues may arise. There may appear to be some conflict between the provision contained in the Arbitration and Constellation Act on the one hand and commercial court on the other hand. It may be, perception may be that, or the situation may be that, yeah, there is a conflict. Now, what should be the approach of the courts in dealing with these conflicts? This is what is the subject matter of this discussion, on which I will, and how the courts have dealt with that and how the courts have tried to resolve it. Now, before I come to that specific issues which have arisen and how the courts have resolved, let us understand the ethos of the Commercial Court Act and as well as the Arbitration Act. As I said, and I have already remarked that before the Commercial Courts Act came into operation and before the commercial courts were established, any kind of dispute, even if it was a commercial dispute, it would go to civil court, but now it goes to a commercial court, and the purpose I have already told you. On the other hand, as far as Arbitration and Constellation Act is concerned, as I have indicated, it is based on party autonomy, which is the fulcrum. And some of the aspects I deal it in the section relating to construction contracts, but I only want to highlight at this stage is that the purpose of arbitration and why the parties who have commercial relationship, business relationship, and the dispute, if dispute arises, they want to go for arbitration, is apart from that it may be speedy, it may be cost effective. How far it has achieved or not achieved, that's a different issue altogether, but that's the purpose of Arbitration and Constellation Act. But apart from these aspects, another very important aspect is that they want to maintain confidentiality. And that is why if you see Section 42A of the Arbitration and Constellation Act, the proceedings have to be confidential. Of course, when the award is challenged in the court of law and under Section 34, so, and the court gives a judgment, naturally the court in that judgment will discuss who are the parties, that would be known, what is the dispute at the reason, and how the arbitrator had decided, and then whether the that award is upheld or it is modified or it is set aside. So to that extent, to some extent, the breach, there would be a breach of confidentiality, but that is because of the reason that when the matter comes before the court, it becomes a public document because the court proceedings are public in nature. And but apart from that, at the stage, and it is not necessary that the matter would be ultimately challenged in the court of law and the parties would like to go to, but they want to maintain confidentiality of the proceedings. For all these reasons, and another thing which you have to keep in mind is that as far as Arbitration and Constellation Act is concerned, the disputes can be of any nature, not necessarily commercial. Arbitration can be in respect of property disputes, say between two brothers. It can be any other dispute of any other nature. So, but as far as commercial courts are concerned, the disputes are only which are of commercial nature. And therefore, the arbitration cases which are per se of commercial nature would go to the commercial court. Now, so therefore, this is what, and coming back to party autonomy, another aspect which I want to highlight here is, and which is important, is that party autonomy is today given a much high credence. Very interestingly, and all of you know, when it comes to court, we have sections 20 to 24 of the Code of Civil Procedure, which discuss about the jurisdiction of the court. And Section 20, we know where defendant resides or where the cause of action has arisen. So suit can be filed only at those places. Now, cause of action or a part of cause of action. And there's one fundamental principle when it comes to the jurisdiction of the court, that if a particular court lacks inherent jurisdiction, even by consent of the parties, both the parties, jurisdiction cannot be conferred on such a court. So therefore, if a particular, let's say, party reside in Delhi, cause of action has arisen in Chandigarh, so suit can be filed either in Delhi or in Chandigarh. But they can't go to Madras Court, High Court, or Bombay High Court, or any other High Court. So therefore, or district courts where they say. So that is very clear law. But when it comes to party autonomy, how the jurisprudence has developed, that two parties, and because it started in international arbitration, one party is say belongs to India, other party belongs to Germany, as I gave the example, and there was a collaboration agreement and dispute arises. They can say in the arbitration clause, they can say that if dispute arises, it will be subject to the jurisdiction of say Singapore International Arbitration Center or LCIA, London Center of International Arbitration. And their jurisdiction is valid. So their parties by agreement are conferring the jurisdiction. And they can even say that the substantive law insofar as contract and implementation is concerned, Indian law would apply. But when it comes to arbitration law and how the proceedings are to be conducted, Singapore law would apply. So very interestingly, a party from Germany, another party from India, if disputes arise, they are sitting in Singapore before SIAC. And when that award is also given, it is challenged in the court in Singapore. So this is what the party autonomy is there. And here the principle of that a court, if lacks jurisdiction, inherent jurisdiction, in the consent of the parties cannot be confer jurisdiction, is given a go by, which was accepted by the Supreme Court in the matter of Sasan Power versus North American Coal in 2014. And in another case, last year only, Reliance Industries versus Union of India, court has gone one step higher. I have given you the example of two parties, one Indian, one German. But what happens to Indian parties? where it may be almost a sort of domestic case, two Indian parties, and if the dispute arise and they want it to be settled, say in SIAC again, the court has held that even that can happen now. So just the way the jurisprudence as far as arbitration is concerned and party autonomy concept is developing. Now, keep this in mind, what I have said, and the purpose behind the enactment of Commercial Court Act. And now let us try to see the interplay which has the way it has taken and the way I would say not apparent but seemingly or perceptionally there has been some conflict between the provisions of the Arbitration Constellation Act and there have been conflict between the Commercial Courts Act. Now, initially, let me come back to Section 10 and tell you one judgment of the court where this issue had been discussed at length. Section 10, as I said, jurisdiction in respect of arbitration matters. And it says, where the subject matter of an arbitration is a commercial dispute of a specified value. Specified value, it is written because depending upon that, and the earlier parts, which commercial court at district court level, high court level, etc., with value, the jurisdiction can be conferred. So arbitration is a commercial dispute. This Commercial Court Act has defines what are the commercial disputes also. So if the arbitration is in respect of a commercial dispute, that is which is defined under the Commercial Court Act, it is of a specified value, then subsection 1. If such an arbitration is an international commercial arbitration, then all application or appeals arising out of such arbitration under the provisions of Arbitration and Constellation Act that have been filed in a high court shall be heard and disposed of by the commercial division where such commercial division has been constituted in such high court. Now it clarifies because normally under the Arbitration and Constellation Act, the one would go to the high court, but then they say of a specified value, suppose the value is only 5 lakhs, and as per that commercial court in the district court is given the power, then irrespective of that, it will be by the disposed of and such commercial division has been constituted in such high court. Now it relates to international commercial arbitration. Now number 2, if subsection 2, if such arbitration is other than an international commercial arbitration, then all application, etc., under the Arbitration and Constellation Act that have been filed on the original side of the High Court shall be heard and disposed of by the commercial division where such commercial division has been constituted in such High Court. Now, therefore, subsection 1 talks of international commercial arbitration. Subsection 2 talks of arbitration other than international commercial arbitration. So it talks of only 2 kinds of arbitration, international and other than international. Now subsection 3, and then I come to the conflicting provisions. If such arbitration is other than an international commercial arbitration, then all applications or appeals arising out of such arbitration under the provisions of Arbitration and Constellation Act that would ordinarily lie before any principal civil court of original jurisdiction in a district, not being a high court, shall be filed in and heard and disposed of by the commercial court exercising territorial jurisdiction of such arbitration where such commercial court has been constituted. So therefore, subsection 3 deals with arbitration other than international commercial arbitration. So one thing which I want to say is that as far as Commercial Court Act is concerned, it talks of 2 types of arbitration when the jurisdiction is given to the commercial court in respect of arbitration matters. Number 1, international commercial arbitrations, and number 2, other than arbitrations other than international commercial arbitrations. Now, this is on the one hand. On the other hand, you come to section 47 of the Arbitration and Constellation Act, which deals with international arbitration. And there it says that it has to be the High Court where it will be challenged and all that would be done. And here, as I've read, it says that it would be, it shall be heard and disposed of by the commercial division where such commercial division has been constituted. And before coming to the issue, then section 21 also I will refer to. Now, Section 21 says, act to have an overriding effect. Save as otherwise provided, the provisions of this act shall have effect, notwithstanding anything inconsistent therewith contained in any other law for time being in force. So therefore, as far as Commercial Court Act is concerned, it has the overriding effect. Now, as per Section 47, international arbitration and dispute arises or enforcement or challenge to dispute, etc., has to be by the High Court. And the provisions on the basis of which the provisions are laid down. And on the other hand, this says as a foreign award, even if foreign award is concerned, it has to be by the a particular commercial court. So in view of this, and if you see the definition of international commercial arbitration, which is set out in Section 2(1)(f), that also would talk of. So on the one hand, we have a non-obstante clause, which talks of Commercial Court Act would prevail. On the other hand, and therefore, apparently, it seems that there is a conflict between Section 10(3) on the one hand and Section 47 on 10(3) of the Commercial Court Act and Section 47 of the Arbitration Act. So this issue came up before, and this is what was argued in view of the provisions of Section 10(3) read with Section 21. This would prevail, and the High Court cannot decide such an issue, and it has to go to the Commercial Court. Now, it came before the court in the matter called Paul's Wind Solution versus GE Power 2021, Volume 7, SCC, page 1. And the Supreme Court maintained that there is no, and because if you know, the first principle of interpretation in such circumstances or such situations is that the court has to make an attempt to harmonize the two kinds of provision. If that fails, then another comes in that then which will prevail. So there the doctrine of what we call lex specialis derogat, legi generally would come. That is specific versus general. They said that specific will prevail over the general law. Special statute will prevail over the general law. So applying these principles, the court said in that case that first of all that there is no clash between Section 10 of the Commercial Court Act and the requirement under Section 47 of the Arbitration Act, and where the arbitration results in a foreign award under Section 44 of the Act, it will be enforceable solely under Section 10(1) of the Commercial Court Act and 10(1), and therefore not before the district court, it will be before the High Court only. And so the two are to be read harmoniously in this sense. And of course, the court said that the jurisdiction of Commercial Court in matter of arbitration, which is noted in the what are those disputes. But then another judgment, if I may tell you in this behalf, is DM Corporation Private Limited versus State of Maharashtra. Here, the question was if the subject matter of arbitration is a commercial dispute of a specified value, which Section 10 says, it has then it has to be held that Commercial Court alone will have jurisdiction to entertain an application under Section 9 of the Act. Now, this is in the context of Section 9 and not, I mean, international and that award. Now, what happens in such a case is that, look, we have Section 9, if you people know about, and you must have read Section 9 of the Arbitration and Constellation Act, which talks of interim measure, that pending dispute between the parties where supposed arbitral tribunal is not constituted so far, and one dispute has arisen, mechanism of how arbitral tribunal is to be constituted is stated in the arbitration agreement, which may take time. Suppose it is said that the one party which has given the notice of arbitration will nominate one arbitrator, other party will nominate its own arbitrator, then the two will nominate the presiding arbitrator if it is a 3-member tribunal. If it is a single-member tribunal, suppose it is said that the parties will go to the court, there is nothing provided how it is to be decided, no arbitrator is named also, then one has to move an application under Section 11 for appointment of arbitrator. In the first case, even if the claimant who has lodged the claim mentions the name, but the other side is given 1 month time, or depending upon the provisions of the agreement, it may be 15 days, but in the absence of that, 1 month time. So it will take 1 month when the other party nominates, and the two parties nominate presiding of arbitrator. So it may take about 1.5 to 2 months. But claimant wants an immediate interim relief in the nature of injunction. Also here the word injunction is not used, interim measures which is used, and section 9 says about that. Now that is one, and once the arbitral tribunal is constituted, then it is section 17, which gives same powers which are given to the court under section 9 are given to the arbitral tribunal to pass an interim measure of the same nature. Of course, the same powers are conferred by amendment under section 15, in the year 2015. Before that, section 17 had, the tribunal under section 17 had lesser powers than the court under section 9. Not, going into that, but coming to the question of the provisions under the Arbitration Act and the Commercial Court Act. Now, what happens where the in a situation where the commercial court refused to refer up, let me tell you here one thing, that another important thing here is, if the arbitral tribunal is constituted, then the courts normally would not go into section 9. Then it has to be before the arbitral tribunal and not before the court, because now arbitral tribunal is functioning, so therefore it should be filed. Now question is, that is what the scheme is between section 9 and 17 before the Arbitration and Constellation Act. On the other hand, power is given to the commercial court. So therefore the issue which had arisen was that, look, if such an application is pending under section 9 and which the court is seized of, here say commercial court under this act, because that power is given under section 10 to the Commercial Court Act, but in the meantime arbitral tribunal is constituted, then what should be done? This issue was settled by the Supreme Court in ArcelorMittal Nippon versus SR Bulk terminal case, where the court said that once the tribunal is constituted, because we have to go by the provisions of the Arbitration and Constellation Act, which says that in such circumstances it has to go. So commercial court cannot retain the jurisdiction. It has also to transfer this application to the arbitral tribunal to decide that. And now this is again based on the principle which I have said, special versus general. The court came to the conclusion that the Arbitration Act is of special nature. Commercial Court Act is of general nature, because all kinds of commercial cases can be decided, and arbitration, where some jurisdiction is given to the commercial court under section 10, is only one of the jurisdictions which, when the cases are arbitration matters. But then arbitration, how it is to be dealt with, and what is the mechanism, a whole body of the law is contained, which is Arbitration and Constellation Act, which is contains the entire machinery, and it is a special legislation. It was again clarified in another judgment, BGS Soma versus NHPC Limited, 2020 Volume 4 SCC, where the court held that Arbitration and Constellation Act, being a special act vis-a-vis Commercial Court Acts, and it would be relevant in determining the maintainability, and therefore the matter has to go to under section 9. Even if the application is pending before commercial court cannot thereafter keep it. Going by the principles laid down under the Arbitration and Constellation Act, the matter has to be sent to the arbitral tribunal, and arbitral tribunal will decide thereafter that application under the provisions of section 17 of the Act. Let me tell you here, many times what happens is, irrespective, because that would be necessary to explain, it would be necessary to explain that many times if the application is filed under section 9, it is before the High Court or the commercial. Now the commercial court is settled, but even section 9, and even if this application is pending, some interim orders, some are passed, interim order of injunction or other order is passed. In the meantime, if the arbitral tribunal is constituted, and that was explained in Asal Mittal also, thereafter the court should not retain that. Even that Section 9 application will say that will be now converted into Section 17 application and will be decided by the tribunal. Of course, tribunal will have right while deciding it finally to affirm the order interim measure which was passed by the High Court, or vacate that or modify that. That entire jurisdiction is with the arbitral tribunal thereafter. Of course, whatever order is passed by the arbitral tribunal under Section 17, that is subject to challenge, because appeal against such an order is maintainable under Section 37 of the Arbitration and Constellation Act to the again it will go commercial court, etc., which will be, and with that how it is maintainable and appeal commercial court, because under Section 37 it talks appeal is there. But we come to the another issue here, which has again created some kind of seemingly some kind of conflict between the provisions of the Commercial Court Act and the Arbitration Act that relates to appeal under Section 13 of the Commercial Court Act. So I come to Section 13. If you see here, insofar as Commercial Court Act is concerned, there also within the court itself, within the act itself, appeals are provided. And Section 13 says appeals from decrees of commercial courts and commercial divisions. So therefore, a commercial court and a commercial division, if it has decided any issue or any dispute, then appeal is provided, if any person aggrieved by judgment or order of a commercial court below the level of a district judge may appeal to the commercial appellate court. Commercial appellate courts are established under the Act itself within a period of 60 days. So it can be commercial appellate, now divisions are created where against commercial court within the district level itself, before the district judge it can go, who is designated at commercial court, or it can go to the High Court, which is if the High Court is the appellate commercial court. Now, on the one hand, this is provided. On the other hand, as I said, Section 37 of the Arbitration and Constellation Act also provides for appeals. Now here, what is relevant is, after this, what I read out to you was subsection 1 of Section 13, then 1A, which was added later. It says, any person, and here the conflict, so-called conflict has arisen, which has resolved by the courts. Any person aggrieved by the judgment or order of a commercial court at the level of district judge exercising original civil jurisdiction, or as the case may be, commercial division of a High Court, may appeal to the commercial appellate division of that High Court within a period of 60 days from the date of judgment of the order, judgment or order. Now here, if the commercial division of the High Court is there, it can again 60 days. So under subsection 1, it was commercial, appellate division within the district court. Under 1A, it is the High Court. Now, proviso is important, which says, provided that an appeal shall lie from such order passed by a commercial division or a commercial court that are specifically enumerated under Order 43 of CPC, as amended by this Act, and Section 37 of the Arbitration and Constellation Act. So therefore, two kinds of appeal are mentioned here. Under Order 43, we know Order 43 rule CPC talks about the appeals, if you know, appeals against the orders. Order 41 CPC is appeals against the judgment and decrees, and Order 43 is against the orders. So that is also mentioned, but Section 37 is also mentioned. So therefore, even if it is an appeal and to be filed under the Arbitration Act under Section 37, it will go to the commercial division, appellate division. Now here, the issue that has arisen in this context is that under Section 37, when it is decided, there is no further appeal. And the question is whether there is a further appeal under Section 13(1) of the Commercial Court Act in the matter of arbitration where the right of appeal is not provided under the arbitration. Here it is provided, and under Section 37 it is not provided. So whether under the Commercial Court Act it can be, what was argued in a case, I'll give you that it is a Kandla Export Corporation versus OCI Corporation. It is 2018 judgment. I have this citation 2018 2 scale 368. So the contention which was raised that in view of Section 13(1)(a), which on this proviso which mentions Section 37 also, the appeal can be provided, appeal can be filed. So that was the issue which was which had been raised, and but the court held in that case that this section. Let me read this three passages from this Kandla judgment, which will clarify. Section 13(1) of the Commercial Court Act, with which we are immediately concerned in these appeals, is in two parts. The main provision is, as has been correctly submitted by Mr. So-and-so, a provision which provides for appeals from judgment, orders and decrees of the Commercial Court of the High Court. To this main provision, an exception is carved out by proviso, which I read out to you. The proviso goes on to state that an appeal shall lie from such orders passed by the Commercial Division of the High Court that are specifically enumerated under Order 43 of the CPC and Section 37 of the Arbitration Act. It will at once be noticed that orders that are not specifically enumerated under Order 43 CPC would therefore not be appealable, and appeals that are mentioned under Section 37 of the Act alone are appeals that can be made to Commercial Appellate Division of the High Court. Thus, an order which refers parties to arbitration under Section, now here the question was, the order which was passed under Section 8 of the Arbitration and Constellation Act, whereby the court had referred the parties to the arbitration. Now, Section 8 says that if there is an arbitration agreement between the parties, but suit is filed, and therefore in the suit, when the court comes to, it comes to the notice of the court that the parties have the arbitration agreement, the court will stay the suit or will not entertain the suit and will say that you relegate the parties to the arbitration, that you go for arbitration. Suppose an order is passed under Section 8 and this the court has said that you go to arbitration because of this. Now this order is to be challenged. Section 37 doesn't allow any challenge to such an order. But if this order is passed, then under the proviso, it is said that so subsection 1A that no appeal can be filed. So he said that no, under this is the order passed by the court, Commercial Court, I have a right to file the appeal. The court held, no, an order which refers parties to arbitration under Section 8 not being appealable under Section 37, 1A, would not be available under Section 13(1) of the Commercial Court Act. So therefore, Commercial Court Act, when it talks of appeal, doesn't mean, if it comes to arbitration, yes, on the one, as it is said, if it is Order 43, whatever orders are appealable under 43, these are all enumerated, you can file. But if it comes under Section 37, then we have to see, and which means if it is an order passed under Arbitration and Constellation Act, and if Section 37, which also says what kind of orders can be challenged, this order is not contemplated. Section 8 order is not contemplated as appealable order under Section 37, then 37 would prevail, and therefore this is not subject to challenge. So that is how the court decided this issue. And if you remember, this Kandla export case, which I am referring to, the High Court view was upheld, and the High Court had taken an. I will like to tell you about the manner in which the High Court had decided, and that portion would be relevant. And it was said that there may be two probable reasons for such a choice. Number one, firstly, that this was done in a matter of that why Section 37, High Court has why Section 37 is added. And if Section 37 is added, one of the argument was that Section 16, which also deals with the jurisdiction, that is not added and Section 37 is added. That was one of the argument which was rejected. And this is that Section 37 is cautiously worded. I mean, the inclusion is by way of caution. That is very ex abentide cautela, applying that principle. And the reason was, very interestingly, the Commercial Court Act came into existence in the year, it was passed in the year 2015, and this provision, as far as amendment to the Arbitration and Constellation Act is concerned, by this amendment, this also came in 2015. And therefore, the court said that probably because of that, when the Parliament was passing the Amendment Act of 2015 as far as arbitration is concerned, on the same day when the Commercial Court Act was passed, so they thought that by way of abundant caution, it was the wisdom of the Parliament, we should mention Section 37 in this proviso to 1A of Section 13. And so therefore, this is what the reason is given, but in any case, this is how it is settled. Now, another question which arises is, what about appeals against, interim orders, etc., which are, as I told you, it mentions about Order 43 CPC, and Order 43 may deal with the, is about the interim orders also. It is Order 41 which deals with the final decrees. But when it comes to arbitration, whether under Arbitration Act against an interim order, normally, except where it is specifically provided under Section 37, as I have told you, normally it is appeal is not provided. I give you the example of Section 16. Section 16 of the Arbitration and Constellation Act talks of the jurisdiction of the arbitral tribunal. And it says it is based on the principle which is in international law known as, and which is applied under the Indian Arbitration Act also, competence. Here, COMPETENZE, it's a German expression which is used, competence. That is, whether I'm competent or not as a tribunal, first I will decide. That court or that tribunal will decide. So therefore, if one of the parties raises an issue that the arbitral tribunal is not competent, it can't raise it before the court. It has to go to the tribunal in the first instance, and under Section 16. But if the tribunal holds, that yes, I have no jurisdiction, matter ends, and it becomes final, because thereafter tribunal is not going to entertain, and it is given the shape of final award, which can be challenged. But on the other hand, if tribunal holds that I have the jurisdiction, then it is specifically provided that that order is not subject to challenge at that stage at interim. Only if the final award, when it is passed and you are challenging the final award under Section 34 of the Arbitration Act, you can take it as a ground that the tribunal did not have the jurisdiction. So therefore, the question was, in these circumstances, suppose Section 16, etc., if it is whether now under Section 13, appeal can be filed in respect of those orders which are enumerated under 43. But Arbitration Act Section 16 order passed, which is interim order, no appeal is provided. Here the court again clarified this is one Kerala High Court judgment, which has come in 2020 only, that appeal can be filed under Section 13 only against final order when it comes to arbitration. Any other commercial courts, etc., yes, if it is order passed by commercial court in a case which was a suit filed before the commercial court, appeal can be filed. But when it comes to arbitration, and from arbitration it is coming, Arbitration Act in that sense would prevail. Another interesting situation, because there are 6-7 minutes left, I will try to cover within that. Another situation which has arisen here, interplay between the Commercial Court Act and the Arbitration Act, is the transfer of pending applications filed under Arbitration and Constellation Act. Now, here Section 15 of the Commercial Court Act says, where a suit, etc., and application which is filed under Arbitration and it refers to Arbitration and Constellation Act relating to a commercial dispute of a specified value pending in a high court where commercial division has been constituted shall be transferred to the commercial division. So therefore, any suit, any application, etc., which is pending under the Act, Arbitration Act, but before High Court, then it will be transferred to the commercial division, whichever commercial division has the power. So therefore, question was, what is the meaning of pending, which is pending? And the court has said that pending means as on the date when this Act came into force, the matter was pending before the date, and not if it is Act has already come into force and some suit or something is filed, there's no question of transfer, because in the first instance it could not have been filed. It should have been filed before the commercial court. Then it will not be transferred. The court will say that, sorry, I have no jurisdiction. You have come to the wrong court. After the incorporation of Section 15 as a Commercial Court Act, you should have gone there. So to that extent, of course, it is the interplay comes, but it is not much of relevance. But there are many cases on that. And one more issue which I would raise here is the question that cropped up for consideration before the Rajasthan High Court as to which of the two courts, namely Principal Civil Court having original jurisdiction in a district as defined in Section 21E of the Arbitration Act, because Section 21E of the Arbitration Act also defines about this jurisdiction. Principal Civil Court, which has the original jurisdiction, will decide the disputes. Whether that or the commercial court constituted under Section 3(1) of the Commercial Court Act, as defined under Section 2B of the Act, would be competent to execute the arbitral award on a commercial dispute. So that was the issue which had arisen before the court, and the Rajasthan High Court, it's a judgment in 2020 only, AIR 2020 Rajasthan, page 56, SK FinCorp Limited versus Suresh Chaudhary. And the court has said that a conjoint reading of Section 10(3) and 15(2) of the Commercial Court Act, which I have already mentioned to you, makes it clear that an application under Section 36 of the Section 36 is where the enforcement of the execution of the award under the Arbitration and Constellation Act. Seeking execution of an award satisfies the requirement of being an application arising out of such arbitration under the provision of the Act of 1996. If such application is pending before the Principal Civil Court of original jurisdiction in a district court, the same shall be transferred to the commercial court. So if it is pending, that would be done. And of course, there was one or two more aspects which are not very material. I need not go into that for want of time. The only other issue which has to some extent arisen, and I'll only take 1 minute in flagging that issue only, that is grounds for interference with the arbitral award, which are mentioned in Section 34 of the Arbitration and Constellation Act. So the issue had arisen, which is again recently in 2019, that is a judgment of Gujarat High Court, is of the territorial jurisdiction. Now here the question was under the Commercial Court Act, the Ahmedabad court also had the jurisdiction, if we apply the principle of commercial court. But the arbitration agreement stated, if the award is given, it can be challenged only before the Rajasthan High Court. The question was, if Commercial Court Act is conferring this jurisdiction on Ahmedabad, whether Ahmedabad is debarred from entertaining because the contract between the parties says exclusive jurisdiction of Rajasthan High Court. And the answer is obvious. The court said that if you have by agreement excluded the jurisdiction of one court, then that stands excluded. And even the provision in Commercial Division Act, if says so, that is the principle even under the CPC as well. If two courts have the jurisdiction, by consent of the parties, the court parties can confer exclusive jurisdiction on one of the high courts. So these are some of the issues, interesting issues, which have, because the Act of Commercial Court Act came only in 2015. It's only 6 or 7 years old, and interplay is coming. Maybe more issues come up, but so far the courts have been able to create deftly crafted the jurisdiction of both the high courts and have tried to harmonize. That is what I say. Thank you.
So we'll have a short break for 15 minutes and be back again at 3:15. Will it be comfortable with you, sir? Kindly.
Yes. So I'm I've logged in. I'm not logging out, but I'll be back at 3:15.
Please, kindly. Thank you so much.
Dr. Balram, judges of
So may I request you to kindly start with the second session.
So this session is about construction and infrastructure contracts. And the two aspects which are to be highlighted here are dispute resolution clause and dispute resolution mechanism. Of course, I will, in the process while dealing with these aspects, try to give a holistic view of these construction contracts and 360-degree views so that it becomes important to then understand the importance of these two aspects as well. Now, the first is that when we talk of construction and infrastructure contracts and the disputes that may arise and dispute resolution clause, etc., when it is said, normally here again, of course, I will specify which are the various modes of dispute resolution in such contracts, but arbitration remains the most suitable as well as which is in demand as well, most preferred, I would say, mode of dispute resolution among the parties in contrast with the court dispute. When we talk of arbitration, and if it is arbitration, and of course before that, as I said, and I'll deal with that, there are sometimes different mechanisms which are provided. It may be arbitration, it may be some set boards, etc., under the arbitration or dispute resolution clauses, that before you go to the arbitration, so utilize those fora. But the question is when it is arbitration and those alternate dispute resolution mechanism which is provided in whatever form, why we give a separate or independent entity to such construction and infrastructure contracts or the dispute resolution. It is like any other commercial dispute. ADR, which is applicable there, is applicable here also. But it is not so, if I may say so. There are some peculiar features of construction cases, and therefore those have to be kept in mind. But before that, what is the meaning of construction contract. What kind of contract qualifies as construction contract or infrastructure contract? In common parlance, we may say that any contract which relates to construction of a particular project or some infrastructure project, etc., it is a common understanding, no doubt about it. But Accounting Standard 7, which is issued by the Chartered Accountant Institute, it has defined a construction contract as a contract specifically negotiated for the construction of an asset or a combination of assets that are closely interrelated or interdependent in terms of their design, technology, and function, or their ultimate purpose or use. So they are normally treated as, these are defined as construction contracts or infrastructure contracts. Then, as I said, what is that? Which are their peculiar features which make construction and infrastructure contracts distinct from other types of commercial contracts? You see, number one, these are very, very highly technical in nature, which may not be, maybe, but may not be in other types of cases. Take the example of construction of a shipbuilding, construction of oil rigs, and construction of course, buildings, but very big projects, colonies, colonization is done, or say housing project for cooperative housing societies project. It may be commercial complexes, like we know these, you go to all these malls, etc. Big hotels, as I've already said, townships, hospitals, national highways, even this airports, construction of airports, all these and sometimes industrial establishments. Now these are very, very big construction contracts which are there, and the construction of each is of a different nature, which is very, very technical in nature. Like if it is a shipbuilding, a totally different kind of technique is required. Oil rigs, if you see the contracts which are there of ONGC in respect of oil rigs and oil exploration, etc., totally different kind. And the construction of buildings, even among buildings, if it is commercial complex, it is different connotation or different kinds of skill. For hotels, it is again different. For township, again different. Hospitals, again different. And I have, I mean, as an arbitrator for last 3 years, decided, or some arbitrations are going on also, which cover almost all. Shipbuilding, I have not so far, but oil rigs, I have, about township, hospitals, hotels, commercial complexes. And I find the contracts which are entered into are of a totally different nature. And many times, in order to understand the implication or in order to understand the technical aspects, one has to really labor a lot. And so therefore, that is first reason which makes construction and infrastructure contracts as a distinct category from other kinds of contracts in respect of which the disputes may arise. Another important, from the economy, etc. Point of view is concerned, you see, construction in India is today the second largest industry after agriculture. Construction of infrastructure, particularly highways and even these oil rigs and even shipbuildings and other airports, etc., which I have said, that is very, very important for the growth of any economy. And you know, as far as highways are concerned, NHAI, National Highway Authority of India, is constituted for this particular purpose. Civil aviation and for airports, etc., we know that Airport Authority of India has been constituted, which is taking care of that. And as far as oil rigs, etc., are concerned, as I said, ONGC, Oil India Corporation, they are especially, I mean, these companies have been incorporated to take care of that. And what I'm trying to emphasize here is that because of these reasons, much importance is given, and it will have its repercussion on the dispute resolution clauses and dispute resolution mechanism. Not only importance is given, they are very, very necessary for the growth of the economy. And it is because of this reason, if disputes arise, now two things which have to be taken care of. There may be, because such contracts, when they are given, they are not to be, these contracts are not performed within few months or so. In some cases, it may take years when the project is completed, because these are very, very big projects. It may take 4 years, 5 years, 6 years, even 10 years, even more than 10 years. Now, contract is awarded either by NHAI or ONGC or any, let's say, airport authority for construction of these particular projects to a particular contractor, and it is going to take long time. In between, some dispute arises. So question is, because of that dispute, whether the contract should come to an end? No. Purpose is, if dispute arises, dispute should be settled, no doubt. But in the meantime, the contract and that project should go on uninterruptedly. And therefore, these kinds of special clauses are normally put in these contract cases also, because that is the aim. And if the dispute has arisen, it may be some particular job which is done, which was not prescribed in the contract. Question is whether it is additional job for which the contractor has to be remunerated, or it is a part of the contract itself, for which the contract price is already mentioned. Dispute may arise. Dispute may arise about the specifications, etc. But and disputes generally which arise, and I'll come to that, are on account of delays, because many times these are in the contracts. You will find time is the essence of the contract. That clause would also be always be there, whether it is to be executed in 3 years, 5 years, 7 years time, that is stipulated. But it always overruns for various reasons. I'll indicate in brief at the relevant time, sometime later. But what I'm trying to say is that the delay, because of the delay, costs are escalated. What was decided or what was thought that within 3 years, if a particular contract is to be completed, and if it has taken 5 years or 6 years, contractor would say that, look, delay is because of the employer, that is the person who has given the contract, the authority, and I am not responsible, but my cost has escalated, you pay. Contractor may, this employer may say, sorry, delay has occurred on your part. But then this dispute may go on, and dispute should be decided immediately, so that the relationship between the parties are maintained and they go on with the contract. Even if it is delayed, project should be completed. That is another very, very important, that yes, the relationship should not be spoiled. Issues may remain, and therefore when the issues arise from time to time, they become subject matter of arbitrations. And many times, another peculiar thing of these construction contract is, out of one contract, sometimes there is 3, 4 or 5 or 6 disputes and 6 arbitrations which go on. I am doing one case of such a contract, construction contract, which is the 4th arbitration before us. 3 have already been done earlier by some other tribunals, etc. But because disputes are different and the project is still going on. So these are some of the very interesting issues. And then another thing is that in almost all these cases, whether it is shipbuilding, oil rigs, or hotels and hospitals or commercial complex, etc., now many times FDI is invited, foreign direct investment. So therefore, foreign players, they come. They may give their capital, they may infuse money, or they may give the expertise, technology, etc. for these purposes. So dispute may arise, and because of the FDI, it assumes the dimension of an international arbitration or international dispute if it arises between the parties. And Normally, because of, as I've said, that these big projects, which infrastructure project, government is the party or government authorities are the parties. So therefore, these are some of the peculiar things which are there, and we have to keep in mind that understand the infrastructure, that there are many kinds of models in which and they will have repercussion on the disputes. Many kinds of models of the contract which have come into play or which are in vogue. If you all must have heard the expression which we started again after the liberalization, etc. If you see most of these industries which I am telling you, whether it is civil aviation, whether it is rigging of oil, etc., oil rigs, or it is shipbuilding, most of these were earlier with the government, with government monopoly, with whether it is telecom sector, whether it is insurance sector, but after the opening of the economy, after liberalization, it is all now private parties which have come in all these sectors. But the government also needs these projects, as I have said. So with the what was started was what we call PPP, private public partnership, where the government and the private sector, they come together and develop a project. A particular highway is constructed, say from Panipat to Jalandhar. Now that is constructed, that is given to the private party, and that may be constructed by that private party. And then after that construction, what is done is that, okay, now toll, the vehicles which will pass through can be collected, toll charges, etc. are fixed, and for 20 years, 15 years, 30 years, that rights are given to the private party, that you have constructed, you have invested your money, now you can realize and make your profits by earning through this means. And after that 20-25 years, you will give back that to the government, and the government will have right either to discontinue the toll or to collect the toll or give it to somebody else. So these are, on that basis, actually, the kind of the projects or these PPPs contracts which have come, types of the contract which are there. I would just because the disputes would be different depending upon the contracts. One is called build, own, and operate. So power is given by the government to that particular private party. You build, you own also, you operate also, you maintain also. Everything is there. Other is build, operate, own, operate, and transfer. First was BOO, then it is boot, B-O-O-T. But you will build, you will own, you will operate, but for 20 years, 25 years, thereafter you will transfer that. Then build, own, and transfer. Again, this is the most popular type of concession agreement. These are called concession agreement, and the person who is given the contract, they are called concessionaire. You must have heard this, that for the duration of the contractual agreement, the private party is responsible for project finance, construction, operation, and maintenance. During the operation phase, the private company recoups its construction cost, operation and maintenance charges by charging fee, controlling tolls, or renting out the space. Following that, a fully working facility is given to the government at no cost. Now, third is build, transfer. Another is build, transfer, and operate. So you can build it, you can then transfer, and the government transfers to do, and you operate it for specified period. Then DCMF, design, construct, manage, and finance. Then engineering procurement, this has become very popular, which I am coming to. This is called EPC, engineering, procurement, and construction. So the methodology which is utilized is to develop infrastructure project, particularly motorways, again highways. The government entity pays. It is a government entity which is paying for all raw material purchase, building expenditure, and other expenses. The commercial entity, that is a private party, its involvement is limited to providing engineering technology, that is engineering and so procurement etc. is by the government, engineering by them, and they jointly construct. Then other is hybrid annuity model, HAM, and this model is often utilized for highways project implementation again, and all these are in fact by NHAI, which has come. And the interesting reason for all this also, I will say, they came out with one project, they found that so many disputes are there, they then shifted to other project, third project. So all these innovative methods are because of the experience with by the NHAI on in respect of these projects and the kinds of disputes which have been arisen. For as far as hybrid annuity model is concerned, which is HAM, this project, the cost is split. Okay, 60% will be paid by the private party, 40% by the government, and it will be constructed. And in this hybrid, thereafter the contract agreement will say that it is the government which will collect, but annuity. And every year, out of those collection, annuity which is decided shall be given by the government to the private party. So these are various. So in a way, capital is taken or borrowed, or some technology is borrowed, but the government will be operating, government will be collecting, but then paying them and on annual basis some fee which is called annuity. Now, these are different, and every dispute will depend if it arises on what kind of contract is there, and each contract has different kind of, each type of contract has different types of clauses also. Now, what is important is, in such cases, I tell you, and the as I mentioned earlier, one thing which is mainly which happens, although time is the essence of the contract, but it is hardly maintained. The contract doesn't get completed within the time which is stipulated. So therefore, these contracts provide for the clauses which call extension because of delay. Now, delay can be on the part of the employer, delay can be on the part of the contractor. There are some delays which may simultaneously be on the part of both the parties, which we call concurrent delays. Normally, what happens is 2 or 3 peculiar things which are in all, and because of that, different kind of disputes arise in contrast with the disputes in other arbitration or other commercial contracts, is that there is a provision for giving extension. But if the delay is, this provisions are normally like this: if there is a delay on the part of the employer, suitable extension will be given, but contractor will not be entitled to any compensation, even when there is a delay. On the other hand, if the delay is on the part of the contractor, extension will be given subject to imposition of liquidated damages, which are liquidated damages are, pre-estimated damages, which can be specified and which are recoverable under Section 74 of the Contract Act. As you know, Section 73 and 74 are the two main provisions where a party has suffered damages because of breach on the other party. Then the party which has suffered the damages will first establish breach, and then will also have to give a proof of how much damages it has suffered. That is Section 73. Now, how much damage and whatever is the actual damage, if it is suffered and they are able to prove, that will be awarded, whether it is in the by the court or by the arbitration. But pre-estimated damages are, which are mentioned and covered under Section 74, that these clauses say that, look, this is the, if the delay happens, if it is on account of delay which we are discussing, the clause regarding liquidated damages say for each month's delay or each week's delay, you will have to pay this much. Of course, subject to maximum of cap is there. 5% of the contract value, 10% of the contract value, etc. That is there. Now, the issue which normally in such cases arise is, and which becomes peculiar and which is to be decided, is whether delay was on the part of the contractor, because we have seen normally the both blaming each other. Employer would say contractor did not bring his full resources, did not mobilize manpower and machinery to execute that, or had faulted in one way or the other, and therefore delay occurred. The contractor, on the other hand, will say there are some obligations which were to be fulfilled by the employer. That is, suppose for construction of highway, I was to be given site, naturally on which site on which the construction is to the road is to be constructed, but that was not given either, or maybe it was there was it was to be acquired under the Land Acquisition Act, acquisition proceedings delayed, or even if it was acquired, there was some encroachment on that, they could not get it done, cleared, and therefore delay occurred, or say it was passing through say forest or some other, the road was passing, and the either permission from the forest department or permission from the any particular municipal authority or permission of any other kind was to be taken, environment etc., which was not taken or delayed. So all these kinds of some agitation took place, so that it can be there. And of course there can be causes which are not attributed to anybody. It may be what we call force majeure clauses. Say pandemic is this, because of COVID, the work could not be done. Lockdown was declared for 2 months, 3 months, for which neither the contractor is liable nor the employer is responsible. So all these situations arise. But what I'm trying to say is, and which I have seen now, the delays, some delays may not have any impact on the even if the delay has taken place, may not have any impact on the progress of the work. Suppose, or even if the delay has occurred on the part of the employer may not be responsible because some other corresponding obligation which the contractor had to perform, it has failed to perform. Suppose I give you example that the contract mentions that site was to be given by such and such date, which is delayed by 2 months. Delay is there definitely, but employee is able to show the contractor was to start the work and had to complete some initial formality like giving the bank guarantees, etc., or signing the contract, and for 3 months that was not done. So even if the bank guarantee is not given for 3 months, so even if there is a delay of 2 months, that is inconsequential, because the contractor could not have in any case started the work, as it has not given the bank guarantee or not signed the contract. So therefore, but this is very easy example I am giving. But I have told you in these kinds of complex cases where the reciprocal promises are there, on the basis of which whether delay is attributed to the contractor or the employer, or it is overlapping, etc., concurrent delay, which I have said, which is of no consequence, vis-a-vis the delay which has affected the contract, which we call critical delays in the legal language. So it is only the critical delay. All this is not easy, for which normally now in the arbitrations we have found the experts coming who are giving expert evidence. Now expert evidence is on delay. Then the expert evidence is also the loss which is suffered because of that delay. Quantum, deciding that. Again, very expertise is required on that. And those expert witnesses on technical aspects, on quantum, delay, technical delay, and on quantum delay, because of that delay. So these expert witnesses are produced from both sides. It becomes difficult. Of course, it has been happening in international arbitrations. From my experience, I found initially, as far as domestic arbitration within India are concerned, lawyers or the parties were hardly producing the expert evidence which is required. because this just will refer to some document that because I have been writing these letters, delay occurred on their part. The other side say I'll be writing these letters, delay occurred on their part. But it is the tribunal or the court which has to decide what is the critical delay. And so maybe the project is delayed by 3 years. Out of these 3 years, 2 years were concurrent delay. Only 1 year was critical delay, but then out of these 1 year, some was on the employer, some was on the contractor, but which was say 100 days on the part of the employer, 200 days on the part of the contractor. So ultimately it is 100 days which is affected, and the employer can ask for LD, etc. for these days. All these become technical issues. So one is the issue of these delays, which become very, very important in these cases. And other is, as I told you, if the delay is on the part of the employer, and many times clause says in that event you will be only entitled to extension of time and not the extent and not any compensation. The question which arises is, and contractor says, sorry, because of this delay, I had to, my manpower was there, my machinery was there was a loss of profits also, because I would have taken it somewhere else, and I have to, here the cost has escalated, so it is a breach on your part. Under Section 73 of the Act, I am entitled. Employer says, sorry, it was very clearly agreed. This clause very clearly says, and you don't have right to claim any compensation, but you can only claim the extension of time. Now, these there are judgments that the parties are bound by the terms of the contract. Now, what to be done? These are called exclusionary clauses, in the way where the right to claim the compensation is excluded. But I am not going into that jurisprudence today. There are much law which has developed and very thorny issues which have been arisen on both sides. But for your benefits, many times when the cases come, I have given few awards on this and tried to analyze. And on that basis, in somebody is coming out with a book, those editors, so they asked me to write an article. So I have written precisely on these exclusionary clauses, which I'll share with Dr. Balram Gupta, and he can give it to you so that you can entire case law on that, most of the relevant case law, and what is the way out. On the one hand, when the contract says no damages, on the other hand, law provides for damages. So which way to go, and how the courts have deemed mostly in favor of statutory right to claim damages. So all these aspects are there, and I would refer to those. Dr. Balram Gupta, I'll send you, immediately after this, I'll mail that article which you can circulate, which contains all those, because I'm not going into those aspects, as our purpose here is about the dispute resolution clause and dispute resolution mechanism. But what I wanted to emphasize up to now was, what are the peculiar features of construction contracts and construction arbitrations, which are not in other kinds of arbitration or commercial arbitrations. But then the question is, as I said, dispute resolution clause. Now, what happens if, I don't know, you may have read it in the newspaper also. Today, only NHAI has suffered the awards. Apart from other public sector, I don't know. NHAI has today awards against us to the tune of 75,000 crores, which are pending enforcement at various stages. So for construction of these highways and delays, etc., because of which they have suffered the awards. So how much effect or cost effect it can be on the not only infrastructure, but on the economy, etc., and ultimately it is the taxpayers' exchequer. So on the exchequer, you can imagine. So therefore, resolution of these disputes. Now I'm coming to dispute resolution clause, and of course I have touched upon dispute resolution mechanism to some extent, but which will follow from there as well. That resolution of these disputes need a special treatment, and dispute resolution clause has to be very, very, innovative in such cases. What has happened many times, and the various clauses, various aspects, and which NHAI also, and our present minister, Mr. Gadkari of Ministry of Road and Transport, has also, I've heard him, has spoken at some places, and it has been stated as well, that we should try that it reaches the arbitration at the last moment. Of course, court thereafter should not at all, but the dispute should be resolved earlier, before that. And therefore, different types of ADR mechanisms which are utilized and which are contained in dispute resolution clause in the contract itself. Then what is that? And it's as a part of multi-tier dispute resolution, and this is now known to be as MTDRC, multi-tier dispute resolution clauses. So these are today, first is, they say, and you will find these clauses which are not normally in other types of contracts, is negotiation. So before proceeding any further, let the parties, and that would be specifically provided, let the parties address the disagreement in a non-adversarial manner, and it entails direct principal to principal negotiation between all stakeholders. They sit across the table. Of course, at the level of the institution or the public sector or the government, very high-powered committees are set up of 2 or 3 persons who are not even given power to settle, but negotiation, etc. So that it is, if there are some genuine claims of the contractor, they should be taken care of at the initial stage itself. After negotiation, next is mediation or conciliation. Now, if across the table we are not able to settle, clauses do provide that will go for mediation. And I have seen, because I have received many times many letters also from some certain public undertakings, that you be our mediator, come on our panel. And at that stage, so that if some dispute arises, then they refer to those persons who are on the panel. And what I'm trying to emphasize is that they want good mediators, or even retired High Court or Supreme Court judges to be the mediators, those who will do that. And sometimes this is, other aspect is, yes, if that also fails, then arbitration is there. But apart from arbitration, there's expert determination. Sometimes what happens is, in our mediation language also, it is called as ENE, early neutral evaluation, or expert determination. Before the matter goes to the arbitration, the public sector or the employer would like to have, because their officers are taking one stand. They think, so as I've given you the example, a particular work which is done by the contractor says it is an extra work, which is not provided in the contract, for which I am paid. So for extra work, I should be paid extra. Or some material which is the specification which were provided. He says thereafter I am asked to provide better quality material. So therefore cost has gone up. I should be given extra for all this. Now the question is, going by the clause or whatever, the employer or their officers may think, no, it all comes within the contract for which we have already paid. So whether it is extra work or not, or whether it is higher quality work or not, so that may give rise to a dispute. But why not go to an expert who should give us the opinion at this stage itself? And if we feel that he may, as I said, it is called early neutral evaluation. He, at early stage, a neutral person evaluates where you stand. So he may say that, look, you may have difficulty. So then it will facilitate, again, settlement of the disputes. And then another technique which is adopted is, and which has become very popular, is either med-arg-med or arg-med-arg. Med-arg-med is mediation. If mediation fails, arbitration. And even during arbitration, we know our Arbitration and Constellation Act says even matter referred to arbitrator, the arbitrator can, if he thinks that there are possibility of conciliation, he can refer it for conciliation, or the parties can think that no, they can again go back to mediation in some respects, or arbitration, mediation, and if that fails, again arbitration. So these are various techniques of dispute resolution which are provided. And I may say here and give quote one judgment. It is again of 2019 given by the Supreme Court in NHAI versus Saidabad Tea Estate. In this case, the court was concerned with or dealing with an application under Section 11 of the Arbitration Act for appointment of an arbitrator in relation to dispute with the NHAI. And the question was whether it is Section 11 application is maintainable or not maintainable in the light of Section 3G, subsection 5 of the National Highway Act. You know, NHAI projects, NHAI is constituted under National Highway Act of 1956. And the central government appoints an arbitrator under Section 3G5 of the National Highway Act. This provision talks about the appointment. On the other hand, Section 11 court is given the power. But then the question which was that appointment by the government under Section 3G or appointment by the court under Section 11. So which of the two appointments was valid? The court concluded that the phrase subject to, which is mentioned in Section 3G5 of the National Highway Act, plainly implies that the legislation intended to give overriding effect to the provisions of National Highway Act when it comes into force, and rather than the this act, I mean Arbitration and Constellation Act, and therefore, if the court exercises the power under 3G, that arbitration would be the valid arbitration. So this I was only mode of this resolution of disputes. I wanted to deal with that and to tell you about that. Now here, what happens is, as I said about delay, I have mentioned. I do not want to state much in detail because as judicial officers, you will be dealing with the enforcement of the awards or challenge to the award which have already been passed. But as far as arbitrators are concerned, it is a difficult job for them of a delay analysis, which has the time time impact thereof, and as I said, delay is critical or uncritical, etc., and how it is to be done. But at the same time, question that arises is another question which, of course, courts are concerned with that when it comes to the enforcement or challenge to the award, is about the evidence, the kind of evidence which is to be produced by the contractor before the arbitrator or arbitral tribunal to prove the losses. Now, many times, in respect of the courts have said, in respect of some claims, it may not be possible to give the direct evidence. Suppose loss which is suffered. It says that for 2 years I could not do. I was concentrating on this project which was delayed by 2 years. So I have loss of profit. Or suppose the contract is terminated prematurely. Full work was not given, and only 50 or 60% work was completed by the contractor. But then the contract stood terminated by the employer on the ground that there is a failure on the part of the, in spite of extensions given, 2 years further extension, and the contractor has completed only 60% work. So therefore, sorry, we are terminating and giving it to somebody else. You are incompetent. And ultimately, the tribunal finds, arbitral tribunal finds no delay was not on the part of the contractor, and therefore the contract was wrongly terminated. So question is the loss which the contractor may have suffered for not allowing to do that 40% work. So what kind of evidence is to be? Normally it is that for, as you know, under Section 73, evidence is to be produced But the courts have come out with this, and we call it, you must be knowing, Hudson formula, or there are three formulas which have become important: Hudson formula, Emden formula, or Ashley formula. But and the court can, the arbitral tribunal, under the given circumstances, and under which circumstance, which formula is to be applied, where even in the absence of direct evidence, some compensation for loss of profit, etc., can be given, and what kind of evidence is to be produced. So this has come for consideration before the court, and I will only give you the judgments which you can read. One is a very famous judgment of the Supreme Court given in 2007 or 8. I think it was a judgment of Justice Sinha, McDermott International versus Bond Standard, where the court has described all these three formulas: Hudson, Emden, Ashley formula, and under what circumstances which formula can be applied for the purpose of computing loss of profit, overhead cost for delay, pendental light, escalation cost, liquidated damages, etc. Why I am emphasizing is because whatever formula is applied and it is given, normally when such an award is challenged, employer can always say that, look, there is no evidence produced. And you will find certain judgments of Delhi High Court, Bombay High Court, etc., which often I am not able to give the citation, where they have said that in the absence of giving evidence, this damages should not be given. So what kind of evidence should be produced, under what circumstances, which formula should be applied, for what purpose it should be applied, etc. All these become relevant for the judges when the award comes for comes under challenge. So these are and other judgment which in this behalf I tell you is you can go to Kailash. This is again relying upon, or rather referring to, or McDermott, Kailashnath Associates versus DDA. It is of, I think, 2017 or 18, authored by Justice Rohinton Nariman, which takes into consideration the entire spectrum and deals with this. Must read these two judgments, which you will be confronted with or concerned with, and you will have to apply the principles laid down while dealing with most of the arbitration, whether they're in construction contract invariably, but even if those are not with construction contract, these two judgment when the awards are given, which will be very, very important for you. As I told you, insofar as exclusionary clauses are concerned, I'm not dealing much with that, and I'll be sending you that that article where all these judgments are. Last thing which I would say, and I'll rest at that, is about the role of the courts, which become very important, and it will take care the kind of approach you should have. There has always been a debate about the role of the court, whether we and this debate always arises as India has not been able to become the hub of international arbitration so far. We go to Singapore Arbitration Center, we go to ICC Paris, and they have office there in Singapore also. We go to Hong Kong Arbitration Center, Dubai International Arbitration Center has come. London, as I said, LCIA is there. Most of the dispute, but when it comes to international arbitration, we hardly have international arbitration. Of course, in those cases where the Indian law is to be applied and seat is in India, so Indian arbitrators are appointed, that's a different thing. But if it is international arbitration, as I told you, normally independent neutral forum is chosen. Say it is between India and England, they may go to Singapore or Hong Kong. But what about if it is Singapore and Germany or Singapore and England? Would they come to India? So far, it has not happened. We have not been able to set up. The first reason which the part normally which is given is by the international community is that, look, in India, the interference by the courts is much as far as arbitration awards are concerned, and delays take place. Now, as far as interference and when it comes to enforcement of the awards, in last 10 years, the Supreme Court has set right the jurisprudence. The message has gone by various judgments of the Supreme Court that no, we are here to, and that arbitration culture has been re-established, which after 1996 Act, for 2 or 3 judgments initially which were given, one was ONGC, Sawpipe, and other was that Bhartiya International, etc., which came under criticism a lot, but now those are either overruled statutorily or even by the Constitution bench. But various judgments which have come, if you read in last few years, they are for the enforcement of the award, because what is said is, and I come back to that party autonomy, that if the parties had chosen their arbitral tribunal, the courts are to support the arbitral system. We should have that arbitration culture, which is conducive for the parties. And the courts are not sitting as appellate court, as if they are deciding the appeal. The jurisdiction of the court to interfere with the arbitral award is very limited under Section 34 of the Act, or Section 45 when it comes to 44, 45 when it comes to international arbitrations. And as Commercial Court Act, you will be dealing with all these aspects. So therefore, this is the culture which we have to, and it is very, very necessary. On the one hand, we should have robust laws which are there. 96 Act was passed. Some hiccups were there on the way, but then we had amendments to 2012, 2015, 2019, which have taken care of most of the aspects. Second is enforcement, where role of judiciary comes. And judiciary has to play its important role. As I said, when it comes to enforcement or interference, the Supreme Court has now given a clear message that it should be leased only when clear injustice is done and the case is decided which come within the 4 corners of Section 34, etc. But even now we have the problem as far as delay is concerned, whether we are able to enforce it within time. So there, I think Commercial Court Acts, when it was, Act came into force from 2015, main purpose was, and as specifically Section 13, which provides for the jurisdiction of the Commercial Court Act to deal with arbitration matter also, is that when the Section 34 petition comes or Section 37, etc., it's against the arbitration award, matter is before the commercial court, so that we have these specialized courts where the judges are well equipped, well trained, and they are able to decide it as fast as possible. So this is the duty of the judiciary which has to be kept in mind. So with that, I conclude my presentation. Thank you very much.
Thank you, Justice Sikri. You know, these 2 sessions have been so engaging and highly contributory with regard to both the aspects which are so significant and important so far as the domain of commercial courts are concerned. I know 2 sessions on a given day to spare was not an easy exercise, and the kind of adjustment which you had to make. Initially, probably it was that the arbitration matters that you had would be in the morning part, and in the afternoon you would be with us. But then somehow in the afternoon, the arbitration got fixed out. That change also you made, and you accommodated us. How should I thank you for all that? Your love for the Chandigarh Judicial Academy has really made these 2 sessions so very important, contributory, and I'm ever grateful to you. Your contribution in future also in our various programs, particularly now we are looking forward to the physical possibility of the programs as such. But this modus of online programs certainly can help us in having the best of resource persons across the country and sometimes even beyond the country. And therefore, we can have many meaningful programs in future in this particular context. Thank you so much, Justice Sikri. We are grateful to you. Thank you.
My pleasure. Thank you. And best of luck, everybody. Thank you.